Here's a due process.
Thank you, and everyone else can be seated. So, welcome back. Thank you. Hopefully you all had a great, restful weekend. Before we get started with each of you, please raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God? Have each of you been able to follow my instructions over the course of the weekend? That is, not to talk to anybody about the people or parties involved in this case, not to do any of your own research, including going online to look anything up, and not reading any of the media reports about this specific case.
Yes.
Great. Thank you all so very much. I appreciate it. So on your chairs this morning when you came in are further instructions. So members of the jury, I'm now going to tell you about the rules of law that apply to determining what amount of punitive damages, if any, should be assessed. When I finish with these instructions, the parties will present additional evidence. You should consider this additional evidence along with the evidence already presented, and you should decide any disputed factual issues by the greater weight of the evidence. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. You are to decide the amount of punitive damages, if any, to be assessed as punishment against the defendants and as a deterrent to others. This amount would be in addition to the compensatory damages you have previously awarded. In making this determination, you should consider the following. A, the nature, extent, and degree of misconduct and the related circumstances, including the following. 1, whether the wrongful conduct was motivated solely by unreasonable financial gain. 2, whether the unreasonably dangerous nature of the conduct, together with the high likelihood of injury resulting from the conduct, was actually known by Gawker Media, LLC, Nick Denton, and or A.J. Delerio. And 3, whether at the time of loss, injury, or damage, Gawker Media, LLC, Nick Denton, and or A.J. Delerio had a specific intent to harm Terry Bollea, and the conduct of Gawker Media, LLC, Nick Denton, and or A.J. Delerio did in fact harm Terry Bollea, and B, the financial resources of Gawker Media, LLC, Nick Denton, and or A.J. Delerio, and C, the degree of reprehensibility of defendant's actions, including the following factors. 1, whether the harm was physical as opposed to economic. 2, whether the conduct evinced an indifference to or reckless disregard of the health or safety of others. 3, whether the target of the conduct had financial vulnerabilities. 4, whether the conduct at issue involved repeated actions or was an isolated incident. And 5, whether the harm was the result of intentional malice. You may, in your discretion, decline to assess punitive damages. You may assess punitive damages against one defendant and not the others, or against more than one defendant. Punitive damages may be assessed against different defendants in different amounts. When determining the amount, if any, of punitive damages to be awarded, you may impose punitive damages to punish defendants only for the specific conduct that you have concluded caused plaintiff harm. You may not award punitive damages to punish defendants for any injury it may have inflicted upon anyone other than the plaintiff. The amount of punitive damages you award, if any, must not be unreasonably large when considered in relation to the amount of compensatory damages that you have already awarded the plaintiff. If you decide to award punitive damages against the defendant, the award should be no greater than the amount that you find necessary to punish defendants for the conduct you have concluded caused harm to plaintiff, and to deter defendants and others similarly situated from engaging in such conduct in the future. You should also take into consideration any mitigating evidence. Mitigating evidence is evidence that may demonstrate that there is no need for punitive damages, or that a reduced amount of punitive damages should be imposed against defendants. You may not award an amount in punitive damages that would financially destroy or bankrupt any of the defendants. So that is the instruction that you have for this. So at this point in time, we're going to go ahead and you will hear the evidence from both parties, and then I'll give you your final closing instruction at the end. Mr. Turkel.
Yes, Your Honor.
Oh, I do have one more. I'm sorry, before you get to that.
I'm sorry.
I'm sorry, there was one additional thing I need to read to you. So, to streamline remaining issues in this case, the parties stipulate to the following solely for the purpose of punitive damage phase of the trial. Solely for the purposes of present net worth as it relates to punitive damages in this litigation, the defendant, Gawker Media, LLC, has a pre-judgment present value of $83 million. Gawker Media, LLC's gross revenues, i.e. before expenses, for 2015 were approximately $48.7 million. Number two, the defendant, Nick Denton's principal asset is shares he owns in Gawker Media Group Incorporated, GMGI, what they refer to it as, the privately held parent company of Gawker Media LLC. For the purposes of present net worth, solely for determining punitive damages in this litigation, GMGI, Gawker Media Group Incorporated, has a prejudgment present value of $276 million, and GMGI's gross revenues in 2015 were $49,951,750. The present value of the portion of GMGI owned by Mr. Denton solely for purposes of punitive damages in this litigation is $117 million. Mr. Denton's assets, other than his shares of GMGI, total approximately $3.6 million. These assets include the equity in his New York City condominium, the contents of his home, bank, and retirement accounts, and shares in Vox, VOX, Incorporated. Thus, Mr. Denton's total prejudgment present net worth solely for purposes of punitive damages in this litigation is $121 million. And the defendant, A.J. Delario, has no material assets and his student loan debt in the amount of $27,000. All right, thank you. Okay, Mr. Turkel, now I'm sorry.
Yes, Your Honor. Plaintiff's offer plaintiff's 563 into evidence.
Any objection?
No objection.
All right, received in plaintiff's 573.
I just have no further evidence other than that which was admitted in the main case.
All right. Then plaintiff's rest at this time.
May we rest, yes.
Thank you. Defendant.
Defendants move in exhibits, defendant exhibit 515 and defendant exhibit 900.
Any objection?
No objection.
All right, then the defense 515 and 900 will be received. Anything additional from the defense? Defense rest?
Yes, Your Honor.
Thank you. Mr. Turkel, close.
Yes, Your Honor.
Thank you.
May it please the court and counsel, members of the jury, welcome back. I want to go through, this presentation won't be nearly as long as we talked last week. The issues are much more narrow for you to consider. Obviously, you've heard the instructions, which are much more narrow than the instructions you were given in the main case. But I want to talk about the purpose of punitive damages because Judge Campbell's instructed you on that already, and just touch a little bit on the fact that the purpose of punitive damages are for you to decide the amount, if any, to be assessed as punishment against defendants and as a deterrent to others. And in that respect, you occupy a unique place. You occupy the ability to send a message. And the simple message that relates to this case is that the line is drawn at the publication without consent of a recording of a private act in a private bedroom. And you can send that message to Gawker for their conduct in this case, and you can send it to others similarly situated. And that's not my language, that is the language of the law. And in that respect, it's a unique opportunity for a jury. You sat here for, 2 weeks, 3, I guess, if we count jury instruction. You took copious notes. You listened to lawyers' arguments for 3 hours. And you know this case. I am not going to go back through it all with you because you heard all the evidence and you were attentive throughout. You are to use your knowledge of that evidence and some of the additional evidence we're going to talk about now to find this number. And I'm going to tell you right now, I'm not going to give you a number. It's very similar to the emotional distress damages in the sense that you are the jury. You saw the evidence. That is your province. And in the jury instructions that you take back with you, one guiding light that you get from the law is that the amount of punitive damage you award, if any, must not be unreasonably large when considered in relation to the amount of compensatory damages you have awarded to the plaintiff. So you have somewhat of a guide there in that you've already assessed compensatory damages. I would submit to you that that's a good guide for you to use, and that punitive should not be unreasonably large as compared to that compensatory award, but it does give you some guidance. You've set some baseline. In that respect, I want to talk about what I think the issue will be, because you're allowed to consider the defendant's net worth, their financial value, or I think the language they use in here are the financial resources of the defendant. And in that respect, we just submitted a document into evidence, number 563. If, John, you could pull that up right now. I want to talk about it because one of the things you were just read from Judge Campbell is the stipulation that Nick Denton's principal asset is the shares he owns in Gawker Media Group, the privately held parent of Gawker Media, LLC, which has a prejudgment present value of $276 million. Gross revenues of close to $50 million. This is going to test your memories just a little bit, but I want, John, if you could go to page 2 of that. This document is in evidence right now. And if you look up there in the first paragraph, you'll see that Gawker Media Group, Inc., the parent, owns and develops intellectual property, or owns Kinja, and Kinja owns and develops intellectual property, which is licensed to Gawker Media, LLC for publishing editorial properties. What that tells you is this, if I can take you through it. Denton's primary asset is stock in this company. This company owns Kinja. Kinja owns all the intellectual property, the website names, their software platforms, etc. And so when the defense, will talk to you about the fact that Nick Denton may have a net worth of $121 million, the truth of the matter is his stock in this company owns everything. They do everything. They can publish other websites. They own the name Gawker. And that's a point that we think is very important when it relates to the financial resources. This is the company that has a present value, according to the stipulation, of $276 million. And again, I think Mr. Kidder testified in this trial that they own the intellectual property, which allows the Gawker world to exist in perpetuity. In that respect, considering those financial resources, your punitive award can take that into account. Can take into account that this parent company can continue to operate Gawker Properties because it owns the actual intellectual property, which serves as a platform for that. Equally speaking, I want to touch on, if you could take it to the bottom of that page, John. Now, this document, by the way, for your benefit, John, the last sentence, I think, on that page. This document, for your benefit, is a pitch document. This is what Gawker prepared to send to investors to review. This is Gawker bragging about Gawker to people that may invest in Gawker. Over the last 12 years, Gawker Media has expanded its early suite of blogs, it says, to a professional publishing stable of 8 owned and operated online media properties in multiple consumer verticals, reaching over 126 million global unique visitors. I am not going to talk about unique visitors again. We know what unique visitors are. I would tell you, if you remember back to Anderson's testimony, he valued a unique visitor at, I think, $6.25 per unique. If we look at the last two, I believe, the last 2 paragraphs on that page, are we on page? We're still on page 2. Go to page 8 if you could, John. And we look at what Gawker was telling its potential investors at this time. It provides it with impressive revenue performance, a strong balance sheet, and an immense strategic expansion opportunity ahead of it. The company sees... Was there an objection? John, could you bring that back up? If you continue to look at the information about Mr. Denton's main asset, it goes on to say there's significant enterprise value in Gawker Media Group with comparable public and private companies valued at 4 to 6 times revenues. With superior historical growth and profitability as well as a robust outlook for the future, the company expressed enterprise value to continue to grow significantly. If we could pull up 22, John. There's a chart in this document. This document is now in evidence. And that chart actually shows the expansion of Gawker Media's group audience, particularly its hold on its prize target, which are millennials. And you see that chart there. Again, this document's in evidence. You can see the growth pattern, which in some respects comports almost directly with what Mr. Anderson testified to. And then if you go to page 23 of this document, you see a ranking of media publishers and their millennial audiences, and Gawker sits at number 2, squarely beneath BuzzFeed, and you see the media companies which it outranks. And the language in the paragraph underneath that they are highly interactive, with 9.5 million of them following Gawker Media Group properties on Facebook and Twitter, and 2.87 million registered users, leaving over 26,700 comments per day to drive news discussions. Again, this is Mr. Denton's main asset. If you go to page 33 of this document, and again, this is a long document, we're just highlighting some things that can show you the financial resources at play with the main asset of Nick Denton. The editorial department at Gawker Media Group drives the independent news journalism and opinion writing that have earned the company both acclaim and scorn for publishing what few others will. So even at a time where it's pitching itself to investors, we get this pride, this badge of honor, that we do things that others won't. Which takes me back to the initial thought I gave you, which is this. You send a message, you make a statement. That statement is we're going to draw the line, and you remember the test, the line. Literally, you draw the line at the publication without consent of a private act recorded in a private bedroom. I want to touch briefly for you on some of the jury instructions just to point out to you how you get there. And I think, I don't know if you'll have a copy there, but John, can you bring those up or not? Like many things that you've been instructed on, it all seems to revolve around your common sense appreciation of the evidence. And if you look at instruction number 2, sub A, when you're determining the amount of punitive damages, you're supposed to look at the nature, extent, and degree of misconduct and the related circumstances, including the following. Not all of these apply. These instructions are built for a wide variety of cases. But if you look at number 1, sub A1, whether the wrongful conduct was motivated solely by unreasonable financial gain, I probably spent 45 minutes talking to you about that on Friday. Whether at the time of loss, injury, or damage, number 3, Gawker Media and or Nick Denton and or A.J. Delario had a specific intent to harm Terry Balea. We could not have been more pointed in the evidence we showed you over 3 weeks about that specific point. Down to the simple fact that nobody cared. I mean, literally, everything was done with a reckless and complete disregard for care and a specific intent to harm this man. Like I said right there, we just discussed B, the financial resources of the companies and the defendants. And I'm not going to argue that A.J. Delario has some sort of huge net worth, because he doesn't. He just doesn't. He doesn't own the stock and so forth. On sub C, you're allowed to look at the degree of reprehensibility of defendants' actions, including the following factors. Number 2, whether the conduct evinced an indifference to or reckless disregard of the health or safety of others. If you look at numbers 4 and 5, whether the conduct at issue involved repeated actions or was an isolated incident, and whether the harm was the result of intentional malice. And you hear these words, reckless disregard, again and again, intentional malice, specific intent, because the law is going to punish that kind of conduct. That's your province, is the jury. And as I said, It is solely your province when you go back there. If you look at instruction number 5, we got that, John? It's page 3, there we go. When determining the amount, if any, of punitive damages to be awarded, you may impose punitive damages to punish defendants only for the specific conduct that you have concluded caused plaintiff harm. You may not award punitive damages to punish defendants for any injury it may have inflicted. That's the wrong 5. You've got 3 up there. I'm reading 3. Yes, Sean? Okay. There we go. Sorry. The award should be no greater than the amount that you find necessary to punish defendants for the conduct you have concluded caused harm to plaintiff, and to deter defendants and others similarly situated from engaging in such conduct in the future. Ladies and gentlemen, your verdict form is very simple. It's going to have blanks, and I'm going to show it to you if you can't get it up quick enough. There it is right there. This isn't as involved a process. You've heard the evidence, and at this point, the duty is to go ahead and assess punitives in amount. You can deter others. You can deter Gawker. And I would suggest you use what you've already awarded in compensatories as a guideline for that. This isn't an involved presentation. This is something that solely rests in your province when you go back there. I've saved 5 minutes. I get to speak last, and I'll address you again after the defendants. Thank you.
May it please the court, ladies and gentlemen of the jury, as you know, my name is Mike Berry. I'm counsel for the defendants. For 2 weeks, as Mr. Turkel said, both sides presented evidence. Both sides presented testimony. Both sides presented argument. After sitting here for those 2 weeks, seeing those presentations, y'all have rendered a verdict. You have spoken, and we have heard your judgment. We've heard your judgment, and we take it very seriously. $115 million. You are now being asked to punish my clients further. An additional punishment that is unnecessary. $115 million is punishment enough. The judge has told you that in this phase of the trial, when awarding punitive damages, she has told you that you must consider my client's financial resources. The amount that you have rendered in your verdict is already far beyond their means. $115 million. Mr. Turkel told you last week in his closing argument that kind of money, hundreds of millions of dollars, he told you, quote, that's the world these guys live in. It's the world of their economics. That's what you were told. But that's not the world of Gawker Media, Mr. Denton, or Mr. Delario. That's simply not the world they live in. You have now heard from the judge that defendant Gawker Media is worth $83 million. That means that if somebody were going to buy that whole company, the entire company, all 8 websites, all of its assets, that is how much it would be sold for. That's it. That's the value of the entire company. And you've also heard from the judge how much money Gawker Media actually makes. You've heard that last year, Gawker Media, the entire company, made a total of $48.7 million in gross revenue. That's how much money came in the door before any expenses, before it paid its employees, before it paid its rent, before it paid for anything. That's how much money it took in. Now, after paying all of those expenses, it must pay an award of $115 million. This is the equivalent of a person having a $50,000 salary, needing to pay his rent or his mortgage, needing to buy his groceries, his clothes, fill the car with gas, needing to pay for insurance and utility bills, phone bills and other expenses, and then still owing someone 2.5 times more than their salary after paying those expenses. That's the position that Gawker Media is now in. Gawker Media owes $115 million. That exceeds the value of the entire company by $30 million. It exceeds last year's revenue by more than $65 million. The amount of the verdict already rendered, the amount of that verdict, $115 million, that amount already could be debilitating for Gawker Media. That amount already has punished Nick Denton more than enough. He's poured his savings into the company. As you just heard from Mr. Turkel, his main asset is his ownership interest in Gawker Media's parent company, GMGI. That company is not a party to this case. It's not before you to be held liable. It's not before you to be punished. You have heard from Mr. Turkel about projections about that company, but you have also heard from the judge about the reality. Gawker's parent company, GMGI, the company that owns Gawker Media, made $50 million total revenue last year. Mr. Denton owns a percentage of that company. Besides that ownership interest, he has total assets of Besides that, he has total assets, as the judge told you, of $3.6 million. That includes his home, his checking account, his savings account, his retirement funds, everything, $3.6 million. The verdict already rendered will be financially devastating to Mr. Denton. The $115 million verdict, as Mr. Turkel told you, that means financial ruin for Mr. Delario. As the judge explained to you, he has no material assets. He has student loans totaling thousands of dollars. He'll never be able to pay $115 million. My clients have heard your judgment. That judgment is serious, and it is clear, and it is punishment enough. As the judge told you, you have the discretion to decline to award punitive damages. We ask that you exercise that discretion. Your compensatory damage award has already punished my clients. Still, if you heed plaintiff's request, and if you believe additional punishment should be meted out, we ask that the ratio between the $115 million compensatory damage award and the punitive damage award be low. Any additional punishment should be small. If anything, it should be just enough to send a message that you believe that some punishment is appropriate. At this point, that punishment should be small. As I said, your message is already clear, as the damages you have leveled are severe. Another large award is not necessary. The judge has told you that if you choose to award punitive damages, you should only award what is necessary to punish Gawker Media, Mr. Denton, and Mr. Delario. And as Mr. Turkel reminded you, to deter others. As I've said, your verdict has already punished my clients, and it will no doubt deter others. Your verdict will send a chill down the spine of publishers, producers, and writers throughout the country. It has sent a message of deterrence already. Men and women in media throughout the United States will surely think twice before publishing or broadcasting anything about a public figure that is even close to the line, let alone anything in an area that seems gray. Nothing more is needed. Your verdict will deter. It is enough. We ask you to consider carefully the consequences of your decision here. Your verdict has already spoken loudly, and it could have far-reaching ramifications. Nothing more is required. Thank you for your attention.
Thank you, Judge. I'll be very brief. It's interesting to me when a defendant comes before a jury and talks about how your message has been heard loud and clear after they spent 2 weeks telling you how proud they were of what they did. Your damage awarding compensatories was not punitive. The first component of it was economic damages, the value that they received from publishing this and the lost value that Mr. Balea was deprived of. Those are financial damages. The pain and suffering, you have to ask yourself this question when the defense comes up and tells you everybody's heard it loud and clear. These are unique facts. We have an iconic figure who's on a world stage. Now, maybe the message gets out to the media, and maybe the media people that Mr. Berry was just talking about think twice before they do this to a celebrity. But when there's not the numbers at stake, when there's not $55 million of economic damages, because it's not going to drive 7 million unique users to their site, and it's just some private person, somebody who just happened to be unfortunate enough to have a sex tape end up in the hands of one of these companies, and it's only going to be $15,000 worth of value, or $50,000. And they look at this case. You good? A punitive award with specific instructions to you to deter Gawker and others similarly situated gives you the right to draw the line, to send that message that the publication without consent of a sex tape taken in a private bedroom between private people is not fair game. When we look, and I'm going to go back to this idea that Gawker is worth, I think the stipulation was $83 million. The reason why I focused on Gawker Media Group, the parent, is because the stipulation says that is Mr. Denton's main asset. Gawker Media, the website itself, does not own its own intellectual property. The other company, which comprises the bulk of Mr. Denton's present worth, owns all of that. And so to deter, Mr. Berry is 100% right. They're not a party to this suit. They are on this stipulation as a reflection of Mr. Denton's main asset. And the truth of the matter is they own all the IP. They can open all the websites. They own the software. And he owns it. And so in assessing his present worth, you're to consider financial resources. That's the word that's used on page 3 of your instructions. Section B, the financial resources of Gawker Media, Nick Denton, and or A.J. Delaria. And so think of it in terms of what you saw on Exhibit 563, which we showed you earlier. And there's the instruction for you right there. That's what you can consider. It's your province to figure out, just because Mr. Berry comes up and tells you they're financially devastated, you consider the evidence, you consider what's been put into evidence, and you consider the financial resources of the defendants. You make that determination. The point we're trying to make is it's been stipulated what his main asset is, and his main asset owns all of it and is worth $276 million. So I'm going to return to where I started at the beginning. And I know it's not easy to sit in this box and have a lawyer tell you this is your judgment to make and not put numbers up and tell you what that judgment is. But that is how the system works. We defer to you on this. And in punitive damages, we defer to you for the specific purpose with which the law vests you, which is to deter Gawker and others similarly situated from doing this. It's just that simple. And I would suggest, again, you use your compensatory award as a baseline, and at the very least use that as some guidance for you to go back there and enter an award of punitive damages against Mr. Denton, against Gawker Media. I will not come before you and tell you a gentleman who has no assets and $27,000 worth of student loans as his present worth. would not be bankrupted or financially destroyed by this. I don't think that's a fair point for me to make to you. So when you go back there, you'll have your verdict form, and we trust your judgment, and we defer to you on what the appropriate amount is. Thank you.
Thank you, Mr. Turkel. All right, members of the jury, you have now heard Yes. One moment. So our jurors want to know, is community service an option in punitive damages? And the answer is no, not in this type of a case. All right. So let's start again. Members of the jury, you have now heard and received all the evidence on the issue of punitive damages. Your verdict on the issues raised by the punitive damages claim of Terry Balea against Gawker Media, LLC, Dick Denton, and A.J. Delario must be based on the evidence that has been received during the trial of the first phase of this case and on the evidence that has been received in these proceedings and the law on which I have instructed you. In reaching your verdict, you are not to be swayed from the performance of your duty by prejudice or sympathy for or against any party. Your verdict must be unanimous. That is, your verdict must be agreed to by each of you. You will be given a form called a verdict form, which I shall now read to you. And it's the style of the case, Terry G. D'Elia, professionally known as Hulk Hogan, is the plaintiff versus Gawker Media, LLC, also known as Gawker Media, Nick Denton, and A.J. Delario, defendant's verdict. What is the total amount of punitive damages, if any, which you find by the greater weight of the evidence should be assessed against the defendants? Gawker Media, LLC, there's a dollar sign and a line. Nick Denton, there's a dollar sign and a line. And A.J. Delario, there's a dollar sign and a line. If you elect not to assess punitive damages against a defendant, you should enter a 0 in the amount of damages and sign and date the verdict form, so say we all, this blank, day of blank, 2006, today is March 21st, and then there's a signature for the foreperson of the jury. So when you agreed on your verdict, the foreperson acting for the jury should date and sign the verdict and just knock on the doors and let the deputy know that you are finished. So you may now retire to consider your verdict, and as before, the evidence that has been moved into court this afternoon, that's plaintiff 563, defendants 515, and 900, plus your verdict form will go back